If you think holding real estate in an LLC or your personal name is a good idea, you're dead wrong. The best way to protect your assets and avoid costly legal battles is by using land trusts. My name is Bishoy Habib and I'm an investor-friendly real estate attorney. I've closed over 1,000 real estate deals totaling $12 billion, and my goal is to maximize profits and limit liability for my clients. In Florida, land trusts have the same liability protection as an LLC, but also offer you anonymity and estate planning benefits. Why do you think the ultra-wealthy families and celebrities have been using land trusts for decades now? Using a land trust can be a game changer for your business, but failing to do so can have severe consequences. In this video, I'll explain the benefits of using a land trust in Florida real estate investing and what could happen if you don't take this crucial step. Don't risk your hard-earned money. Learn how to protect yourself and your business today. Last year, nearly 60,000 lawsuits were filed in Florida. That's the most in the country and more than double the number 2 state, which was New York. Florida is now officially the most litigious state in America. If you own property here, you're not just an investor, you're a target. And today, I'm going to show you why rich people don't hold real estate in LLCs or their personal names, but rather in land trusts. Florida land trusts are a powerful legal tool that have been around for over 60 years, yet hardly anyone uses them. They've actually been around longer than LLCs, believe it or not. But most real estate professionals and investors don't understand how they work, so they default to the LLC because it's easier. Don't make the same mistake. Florida is one of a handful of states that has specific land trust laws. And actually, Florida has the best land trust protection for investors in the entire country. Now let's talk about the reality of owning real estate in Florida for a second. First, every property you own in Florida is public record. Within 30 seconds flat, anyone in the world can find out exactly what properties you own and what they're worth. Think about that. Most people would never be okay with the public being able to see our bank accounts or our stock portfolios, but for some reason, we just accept it with our real estate holdings. Even if your properties are in an LLC, all your LLC information is public on www.sunbiz.org. Second, Florida has created an environment where litigation has become a lucrative industry. I'll let you in on a dirty little secret from a friend of mine who's a personal injury attorney here. The biggest factor in deciding when to sue someone is not the strength of the case. It's actually whether the defendant has assets or not. The attorney's investigators specifically look for people with real estate assets because they're easy to identify and they know they can collect. Holding property in an LLC still allows the public to find out what you own, and holding property in your personal name allows attorneys and creditors to lien or seize that property in a lawsuit. That's no good. This is where land trusts come in. Think of a land trust as a private vault for your real estate. When set up properly, you, as the owner, remain completely anonymous while maintaining full control of your property. Let's break down the key benefits. Number 1, anonymity. Your name never appears on public record. It prevents you from being a target for lawsuits, and it shields your portfolio from competitors and curious parties. Now, a lot of my clients ask me, well, Bishoy, why would I put my assets in a land trust if I have nothing to hide? And to those clients, I say, you're missing the point. It doesn't mean you're doing anything shady just because you're using a land trust. It really is a way to prevent frivolous litigation and create barriers to add layers of protection so that people don't come after you for no reason. Number 2, asset protection. And this is specific to Florida land trust. As I mentioned earlier, in Florida, land trusts offer the same protection as LLCs, and most people don't know that. That's actually by law. It's in the statute, which is Florida Statute 689.071. So what this does, it limits your personal liability. So you don't really have any personal liability, the same way that you wouldn't with an LLC if it's all structured correctly. It also prevents certain types of liens from attaching against your property. And if you structure it properly where you have one land trust per property, it creates separation between each property to contain the liability. So if one tenant slips and falls in this property, they can't sue you for other assets you own, such as other properties held in other land trusts. Now, I also want to point out an important concept here, which is piercing corporate veil. I won't dive too deep into this, but it's the same with LLCs. You want to make sure that you're doing the right things so that people cannot pierce the corporate veil. The number one way to pierce the corporate veil is if you're commingling funds. So if you're using the business's funds for personal expenses, then you can be personally liable for the company's liabilities. That's no good. We want to prevent that by any means possible. That's probably a topic for another day, but you want to make sure that you're not piercing the corporate veil. The third major benefit to the land trust is the estate planning. The land trust actually helps you completely avoid probate, which is huge. Now, if you've been through a probate process in any capacity, you know that the only way to describe it is painful. You have to pay legal fees to attorneys to go through a court process that could take 6 months, 9 months, a year plus, depending on how many assets there are. If there's a lot of money involved, there's probably fighting between the family as to who gets what, and it's all public. Those assets that are in probate cannot be sold or disposed of in any way until the probate is complete, which, as I said, could take over a year. With the land trust, you avoid all of this. It allows the immediate transfer of that real estate upon the death of the owner. It prevents family disputes over an inheritance, and it just makes it a much smoother process. And finally, there are operational benefits to using a land trust. It could simplify management for multiple owners. It can enable creative financing strategies. I have a lot of clients that I prepare land trusts in order to do subject to transactions. It just makes it easier, smoother, and it protects both parties ultimately. And it makes property transfers easier. So what you can actually do, and it's nuanced, so I don't recommend it, but you can actually transfer the property within the land trust if you transfer the beneficial interest. It makes it more private. It makes it easier. You don't actually have to record any documents. Now, let me give you some real world examples. We'll start with a client of mine named John. John owned 25 rental properties worth about $12 million in separate land trust. In 2022, at one of his lower end rentals, he genuinely messed up. And it happens. He ignored multiple maintenance requests about a damaged staircase, and eventually a tenant fell and suffered serious injuries. Tenant had to get surgery, and it was a lot of money at the hospital bills. Now here's where it gets interesting. When the tenant's attorney ran their standard pre-lawsuit asset search, they found virtually nothing. The property was held in a land trust with a professional trustee. Despite John owning a $12 million real estate portfolio, the only assets they could link to him were his homestead property, which, as we all know in Florida, nobody can come after, an 8-year-old Mercedes-Benz that John drove, and a basic checking account. The attorney assumed they were dealing with a low net worth defendant and offered to settle for $70,000, which was less than his insurance policy limits. John's insurance covered it, and John paid $0 out of pocket. Now let's look at Sarah, who owned just 6 properties worth about $3 million in 2 LLCs. Sarah's tenants tripped over a sidewalk crack that had just appeared about 1 week earlier and was already scheduled for repair. The injuries were minor. There was some bruising and a sprained wrist. But when the tenant's attorney did their asset search, public records showed Sarah owned both LLCs. Using that information, they found all 6 of her properties along with the property values. The attorneys pretty quickly calculated that Sarah was worth over $3 million, and what happened next was brutal. Despite having no negligence and minimal injuries, the attorneys pursued the case aggressively, knowing Sarah had significant assets and would probably be willing to pay a lot to settle. They dragged out the litigation for 2 years, ran up her legal bills, and kept pushing for a jury trial in Miami-Dade County, which is known for large plaintiff verdicts. After Sarah spent $50,000 in legal fees and countless sleepless nights, Sarah ended up settling for $350,000 to avoid the risk of trial. Even with her insurance policy, Sarah paid $300,000 more than John, even though John was dealing with a much more serious case where he was actually negligent and was worth significantly more money than Sarah. This is the reality of asset visibility in Florida's legal environment. John's actual negligence led to serious injuries, but his use of land trusts limited his exposure by keeping his wealth private. Sarah did almost nothing wrong, but her public LLC ownership made her a target, costing her over $300,000 out of pocket, plus her insurance premium got jacked up after that. The difference wasn't justice. It was simply what the attorneys could find. So here's my question to you. Would you rather pay your attorney a couple $1,000s today to protect you so you could sleep well at night, or pay someone else's attorney 6 figures tomorrow because you cheaped out? Setting a land trust up is not complicated, but it does need to be done correctly. Here are the key elements. Number 1 is the trust agreement. Think of this like an operating agreement for an LLC. You want to put the parties in there, their names of the trustee, beneficiary, successor beneficiary, etc., and establish the trustee powers. You have to include certain language in here from the statute. The land trust agreement defines the rights and responsibilities of the party. And this document is where we would say, for example, you as the owner have full control over the land trust. The trustee does not have any actual control or management rights. They're just a figurehead. Second is the trustee deed. And this is very important because it seems very simple, but I'm telling you a ton of potential issues lie here. And I'm telling you this from my experience, and I'll give you a couple examples. So the deed, as you know, transfers the property from whoever owned it before into the trust. But the thing is, you can't transfer it into the trust directly. You have to transfer it to the trustee of the trust. So the very first thing you have to know is that the trustee's name appears on the public record. The first mistake I typically see is that people try to move it directly into the trust, and that deed will fail. You will not be able to move it into the trust unless you deed it properly. Number 2, you cannot use a regular quitclaim or warranty deed. And if you do, you run the risk of not having the benefits of the land trust. You have to include specific statutory language from Florida Statute 689.071, which says that this is a land trust and that you have the protections of the land trust statute in Florida. Deeding it wrong and not making these simple steps correctly could void the whole thing and basically make it pointless. Now, the deed also requires proper execution and recording, as with any deed. As far as an operational structure, we like to put separate trusts for each property because, as we mentioned earlier, that limits the risk exposure to each individual property. You want to have a nominee trustee, and I won't dive into that, but that's something I talk about with all my clients. And you want to have a clear documentation system so you can track everything that's going on, because remember, none of this is public. So you need to do a good job maintaining your records. I, as an attorney, of course, maintain the records for my clients, but you also should do a good job, because if something happens to you, you need to let whoever's next in line understand that this property is yours once I pass away. So you need to document that. It's not public record. So that's always an important step. Now, I want to talk about a couple misconceptions. I've been doing this a while. I've been doing this 12 years now, and I wanted to clear some things up that I get asked all the time. First of all, land trusts are not tax shelters. Actually, land trusts have zero tax implications. You know why? Because they don't even have an EIN number, they don't have bank accounts, and they don't file tax returns. They are pass-through entities. So all the tax ramifications come from whatever is inside that trust or underneath that trust. It's a pass-through entity. So if you own that land trust individually, you file individually. If it's owned by a company, that company has the tax ramifications. Number 2, land trusts are not illegal or shady. There's nothing wrong. It's just steps you're taking to protect yourself. Number 3, they do not make you immune from legitimate creditors. I get very nervous when attorneys start talking about bulletproof, because nothing in the world is bulletproof. There is no such thing as being 0% chance of liability or having 0% chance of liability. So if your attorney's telling you that, or if you're watching a guru on Instagram or YouTube who's saying you can make yourself completely immune, that is false. Be aware that is not the case. What we do is we create as many barriers as we can for these frivolous lawsuits, and even if they're legitimate, but we still want to protect ourselves, that's all we do. We create barriers, right? And so a land trust is one big barrier. It's not the only one, but it's a big one. And finally, land trusts are not complicated to maintain. They're very simple. As a matter of fact, there's no filing fees, there's no annual fees, there's no maintenance basically, unless you want to make modifications to it. So theoretically, I could set you up with a land trust today, and we wouldn't have to touch it for 20 plus years if that's what you wanted. As I always tell my clients, you can't shoot what you can't see. That is a land trust summed up in one sentence. So while land trusts are not bulletproof, they are the best way to hold real estate in Florida. They offer the same liability protection as LLCs, but they include anonymity and estate planning benefits as well. Land trust creates essential layers of protection between you and potential threats. It's like having a protective bubble around your real estate investments. The ultra wealthy have been using this strategy for decades. It's time more investors understood this powerful tool. If you've ever had issues with property ownership being public, or somebody coming after you or finding your name on the public record, drop a comment below and share your experience. And if you want to learn more about protecting your real estate investments, hit subscribe and click the notification bell.